So we are ready.
This is Linda Katz with the State Bar of California. And before we can call this meeting to order formally, I have to note that our chair is not able to attend today's meeting. So I wanted to ask for a motion for a pro tem chair. Judge Yu has graciously agreed to serve in that role. So I'd like to invite one of the members to formally move to appoint Judge Yu as the pro tem chair for the purpose of this meeting.
So moved.
Second.
Stephen Hamilton, second. Oh, sorry.
So it looks like it's been moved and seconded. Is there any discussion? All in favor, please say aye.
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 Any opposed? Okay, thank you so much for entrusting me. I told Chris I would try not to botch it up on his behalf. I know Leah is running a little bit late, and I think everybody, hopefully you can all hear me, and I think everyone got the PowerPoint and then the vote records, and Leah's here. I think that pretty much today, we're not gonna make any substantive decisions about the topics that we're gonna be covering. We're really just going to be discussing the next steps for the plan. And so who would like to start? Leah, would you like to go over the PowerPoint at this moment?
Yeah, and I think actually Linda's gonna kick us off and I'll jump in as needed.
Thank you.
Should we do the
Okay.
roll call prior to? Or?
Yes, Araya, go ahead, sorry.
Oh, sorry.
Thank you. So I'm going to go ahead and call out the names, and if you could unmute and let me know that you're here, that would be great. So starting with Bashan.
She's here. I'm just promoting her over.
Okay.
Here.
Brynelson,
Here.
Felmuth,
Here.
Fleischman,
Here.
Hamilton,
Present.
Hartston,
Here.
and the chair, Chris Iglesias, is not present. McRae,
Here.
Olvera,
Here.
Shining,
Here.
Sarouche,
Here.
Spyro,
Iris sent us a chat. It was from Anna Hawkins to all panelists. It says,
Oh.
I'm watching and listening, but I don't think any of you can see or hear me. So maybe he has to be promoted as, I think he's using Anna Hawkins as the.
I see, and I do see that.
I just promoted him.
Thank you so much.
Okay, thank you. I will note him as present. Thank you.
Thank you.
And Judge Judith, before we get started, I just thought I'd quickly make a comment about the PowerPoint. I guess, can you hear me okay? I don't know if my connection is good. Okay. I am no expert in Bedley Keene, but I understand that I think if it matters, the materials are.
I'm so sorry to interrupt you, but you're right. The sound is spotty and it's kind of breaking up, so we're not getting all your words.
Okay. It's kind of important. So I just wondered if you can hear me. Can members of the public see this PowerPoint?
The question is, can members of the public who are logged in see the PowerPoint displayed in the Zoom? I would think yes, but I'm going to defer to Linda or Leah, or maybe even.
The PowerPoint, I'm sharing that, and it should be visible to members of the public.
Yes.
Anybody who's able to log into the meeting.
Okay. I think this PowerPoint, I was concerned last meeting when I was told this was a scheduling meeting, because I thought there could be a lot of stuff that would be not scheduling that could be discussed. And so I asked Leah and Linda to send me whatever they were going to show at this meeting, and I got it last Thursday. And I think we all got it last Thursday, actually. And I think things like this need to be distributed to the public if they're distributed to everyone. I don't know the dates on everything, and maybe it was sent inadvertently to everybody. I just asked for it. But there's a lot that's substantive in here that I don't think reflects what we've worked on and talked about yet. So I think it's really important to get to that. We can talk about scheduling, but I want to make sure members of the public have this because there's a lot of new information in it before we go into the deep dive.
I think when it's posted to the State Bar website, it's available to the public, just like our agenda, but I will defer to State Bar staff to confirm my understanding.
Yeah, what I would say is there's not been a historical typical practice of posting web PowerPoints that are used for various agenda items on committee meeting agendas. So the way that we share it with the public is by having a public open meeting, which this is, and everybody can see the PowerPoint at that time. And so this is kind of the standard State Bar practice, and we're doing it with this meeting. I'm not seeing sort of an issue with the PowerPoint, and that, to my knowledge, is the only material that we have for today.
Okay, so just so you know, I can just let you know, Carolyn, that somebody says that they can see the PowerPoint but can't understand you. So I think there's a sound issue. Maybe you can try to work on that as we move forward. And then yes, we should ask for public comment at some point. But I wasn't sure. Did we finish taking the roll?
Yeah, Araya, did you?
Yes.
Roll?
Okay, great.
Let me work on my connection, but I don't think this was posted to the agenda.
It may not have been.
No.
Okay. So back to Linda.
Yeah.
Sorry, Carolyn, were you saying something? It's
Oh,
all powerful.
Yeah, I'm gonna hang up and dial back in on a different connection.
Okay. And then Linda, I'll turn it back to you.
Okay, thank you. Can you hear me okay? The
Yes.
sound is good. Okay. So first I wanted to start just with a very brief recap of the activities of the working group so far. At the first meeting in April, we provided an overview of relevant background information, including the Justice Gap Study, the ADLS report, and some other work that the State Bar has done that fed into this initiative to form this working group. Some initial decisions were made regarding the practice areas that would be excluded from ongoing consideration for the paraprofessional program, and those were criminal and immigration. There was agreement that on certain areas that would definitely move forward for ongoing consideration, not that they would definitively be included, but that they would be, the working group would consider them for further consideration. Those were family and children in custody, name and gender change, consumer debt, and employment. And then there were the wobbler practice areas where the working group determined that additional information and research was needed before making a determination about whether they would be considered for, included for ongoing consideration. Just as a review, for the wobblers included veterans, collateral criminal, estates and trusts, general civil, health, housing, and income maintenance. And the wobbler review process consisted of additional research by one or more group members that included the review and analysis of data. And I don't need to read everything that's on this slide, but there was additional data provided to the working group of the wobbler working group members. We reviewed some reports. There were meetings with subject matter experts, including people who run legal services programs that were relevant to the particular practice area, veteran service organizations, law school clinics, and practitioners. We met with judges. We reviewed administrative appeals process in the areas that were relevant. And we also had a couple of opinions from the Office of General Counsel. Sorry, there seems to be a little bit of a lag. Decisions were made with regard to all of the practice areas, the wobbler practice areas, about whether they would be included or excluded. And for the areas that were moving forward, there were subtopics for each of those areas identified. And so for the wobbler practice areas where the subtopics have been identified, we're ready to move into the next step, which is the deep dive process, which I will discuss in a few more slides. So in income maintenance, we're looking at state administrative agency proceedings. For collateral criminal, it was agreed that we would look at expungement and reclassification of convictions, as well as infraction resolution. In the housing area, we're looking at unlawful detainers and homeowner issues regarding clearing of title. Under general civil, there were several categories: civil harassment, representation of debtors in enforcement of judgment, enforcement of small claims court judgments, as well as representation of creditors and wage and hour claims. In health, the subtopics that were identified were billing for medical services, denial of access to services, denial of insurance, and failure to inform free services available. And then for the subtopics that were not wobblers, but they were just at the initial meeting, there was agreement that they would be included for ongoing consideration. We still have to determine the subtopics that will be included. So for those, it's the originally identified practice areas of children in custody, consumer debt, employment, and family. And so the next step is going to be to apply that wobbler process to those practice areas by appointing two-person teams, which we'll do later in today's meeting. So with regard to each of those areas, if we look at what was found in the Justice Gap study, these are the areas. And in children in custody, this is a list of each of the, this is sort of the definition for children in custody for the purposes of the Justice Gap study. Questions were asked about each of these areas: custody and visitation, child support, paternity, issues regarding child protective services, dependency, and aging out of foster care. And the asterisks are next to the subtopics that were identified as areas of greatest need through that Justice Gap survey. Under consumer debt, which the Justice Gap survey formerly called financial issues, what you can, and I'm not going to read the whole list, but the areas that were identified as those of greatest need, they were unfair lending practices, harassment by creditors or collection agencies, and utility shutoffs. In employment, these are the questions were asked about all of these different areas, and the ones that were identified as those of greatest need for Californians were unsafe working conditions, unfair termination, and someone who filed a workplace grievance that was ignored, not taken seriously by their employer. And under family, the topics that were areas of greatest need were divorce and separation, domestic violence, and elder abuse. So what do we mean by deep dive? So for the areas that were wobblers, where we've identified the subtopics, the next step is going to be to do a deep dive. And these will be, the deep dive will be a facilitated discussion where we'll bring in judicial officers who hear cases in their relevant practice area, as well as when, where it's appropriate, practitioners, expert practitioners in that field. And the purpose of those discussions will be to finalize the subtopics, that will be included in the paraprofessional program, and to specify the tasks that will be allowed. And what you'll see later on, where we want to finalize the project plan, what we're recommending is to have a deep dive in just 3 or 4 subject areas in an all-day meeting. So if we had a 6-hour meeting, just have time to have an in-depth discussion to determine the subtopics and the specific tasks that would be included. And so today, what we need to decide is, in terms of, you can see there's a number of different topics that we need to cover. So we want to look at whether we're going to merge some of them. For example, consumer debt and general civil might make sense to do a deep dive on those together, because there were categories that we found some overlap in terms of the subtopics. We want to look at the practice areas, the determination of the subtopics for children in custody, consumer debt, employment, and family. We want to identify the 2-person teams that will perform do that wobbler process to recommend the subtopics. And then the final thing we want to do is to sequence the practice areas to be put on the agenda for the next few meetings. So we have a meeting for August where we're going to have to come up with the subtopics, and then potentially do a deep dive in one of the other areas. And then in October and December, we'll want to use those meetings to deep dive on the remaining topics.
So, Linda, if I could jump in for a minute.
Yes.
One, with respect to the first column on mergers needed, I think several of you identified the challenge of the overlap. There was lots of overlap in income maintenance, for example. We talked about unemployment hearings, workers' comp hearings, which also, of course, subject matter wise fall under employment. And so what we want to do is engage you in some discussion of whether or not the categories as they currently exist make sense, if we should proceed with them at least until the August meeting, and maybe then in August, when we see where we are, begin to collapse or merge categories. But just really to acknowledge that there is overlap, and that perhaps the way that they're broken down right now is a bit artificial. So that's the intent there, is just to really get your thinking. And it may be now that we do merger, or we may have that on the table for later at the August meeting. And then I also wanted to point out that you don't see name and gender change as one of the categories where we're recommending that a 2-person team be established. That's because we feel that that one is likely to be fairly simple, and that we could tackle it at an in-person deep dive session rather than needing to work it up in between. But if anyone disagrees with that, then name and gender change should be added as another area that needs a team. And then the last thing I want to say, and maybe Brady, you can speak to this, is there's lots of questions about the number of people on the teams. And if today we establish teams formally, the teams need to be 2 people or less in order for us to have that ability to meet sort of flexibly between now and the August meeting. If we make them larger than 2, we will trigger meeting notice requirements, which I think no one is concerned about making the contents of our discussions public, but it has been very difficult to schedule these. And so we need to keep that in mind in thinking about a group larger than 2 created sort of formally by this body today. So Brady, do you want to speak to that for a moment? Because I see some questions about that.
Sure. It's in the Bagley-Keene Act, which we discussed at the last meeting. The government code specifically provides that since we are, we the working group, are a state body subject to Bagley-Keene, if by formal action, we create a group, a subgroup of more than 2 people, then that would necessarily also be subject to Bagley-Keene. And what that would mean is that rather than, sort of meeting informally and having the ability to quickly schedule meetings, we need to post notice of them publicly at least 10 days in advance. So that's sort of the trigger point, having more than 2 people. And if there are any specific questions, I could answer those.
Yeah, can I just interrupt because I do see hands from Carolyn, Steve Fleischman, and Steve Hamilton. Carolyn, you're first in the list, I think.
Okay. Well, I appreciate a lot of what Leah said, and but I do think this is, and I do appreciate the 2-person thing, and I do appreciate having to kind of narrow these things down. One quick point is who we will invite in. And I think Leah mentioned judges and lawyers. I'm hoping that if we have some of these broad categories, and I would like to read the categories, and because I think people who can't see that screen or didn't have time, we flew through those things. We mentioned these things at the first meeting. We're in, is the word we used. And then, in this PowerPoint, it talks about originally identified, and that just says the word employment. And then it says a recap of key activities to date, and it says those to move forward for further consideration. So it always was the word employment and the word consumer debt and the word name change. So now we've got employment, wage theft, workers' comp, unsafe working conditions, unfair termination, failure to accommodate disability, unemployment benefits, workplace grievance ignored, sexual harassment or intimidation. And, there's as lengthy a list under consumer debt, which includes things like bankruptcy and things that we've already discussed. So I really think that I would, for one, would like to bring in other people such as psychologists who will discuss the trauma of sexual harassment and workplace discrimination cases and how those may or may not be appropriate. I thought we discussed all that, and we can talk about that more specifically. But one, I want to make sure that on these teams, we're going to be allowed to bring in the people that the working group and the people on the teams feel are relevant and documents that we think are relevant. So that's a question for Linda and Leah. Are we going to be allowed to do that?
And Carolyn, before we answer that question, I just wanted to clarify, and I think I did go through some of those slides relatively quickly. What I put up there was just to show how those legal areas, the subject matter areas, were defined in the Justice Gap study, and what the types of questions were asked in the Justice Gap study, and those that were identified in that study as the areas of greatest need. That is was not meant to imply that those will be the subtopics that will be identified by the working group for ongoing consideration for paraprofessionals. That was just pointing back to the Justice Gap study. And I apologize if I wasn't clear about that in the discussion of that slide.
Thank you, Linda. So it's Steve Fleischman.
Okay, but just to explicitly
Oh, sorry,
Carolyn's other question, the answer is yes. And I think from your experience on the health team this last go around, you're familiar with the fact that you all on those teams identify who you want to talk to. In addition, staff will try to find relevant subject matter experts. But really that is the team's process to lead who they want to talk to, what reports they want to look at.
Thank you. Sorry. So now it's Steve Fleischman.
Yeah, I'm looking at the middle column of this slide. It seems to me this is actually relatively simple. Children in custody should be folded into family. Consumer debt, I think, was already addressed in general civil and should get folded into that group. Employment is fraught with problems, but there's significant overlap with income maintenance. Income maintenance already has remaining issues to resolve. And I think employment should just be assigned to the existing committee on income maintenance, which admittedly turned into 4 people, but I'm fine with that. And I'm fine with complying with Bagley-Keene on that. And then I think family is a big issue that needs to be tackled. My other general comment is, I mean, we've done a tremendous amount of work already. I'm in the back of my mind worried we've bitten off too much to chew. And I'm looking forward to what Leah called the, you know, the funnel of peeling things off, because every one of these categories, we're going to have to think about regulations and other things. And I realize that's, you know, probably in next year. I just, in the back of my mind, I'm worried we've bitten off more than we can chew.
Okay, thanks, Steve. I might come back to you to ask if you have a motion to combine things after others have been heard.
Thank you.
Sure. Next is Steve Hamilton.
Stephen Fleischman stole my thunder. Absolutely. I think family law needs to be consolidated with child custody and visitation. There is so much overlap there. If you look at the child custody and visitation, you've got support listed. Well, you've got child support issues and dissolution. And I think one of the big things is we could end up sending conflicting messages out to interest groups that we would contact in that process, where they're being contacted by one group for custody and visitation and another group by division of assets and debts and family law. We're dealing for the most part with the same judicial officers and the same interest groups. So I would recommend that we consolidate those two and include within that guardianships, because we did indicate that those were going to be included as the one area of probate that needed to be addressed, and that's a logical place to put it. And then with regards to the, I'm sorry, oh, go ahead.
Just real quick, would name and gender changes fall under family?
I'd put that in civil. And the reason is because you would be in a civil courtroom to petition for a name change.
Fine, let's leave it. Let's leave it plain.
Yeah. And then with regards to the size of the committee, under Bagley-Keene, we can never have a majority or a quorum meeting independent of the fulfilling the requirements for notice. But that means we can have up to 8 people. So that doesn't respond to the scheduling issue. I think it would be a mistake to make family law only a 2-person team. I think that needs to be bigger because of the scope of the area, and because that is the one area which every single state that's had a paraprofessional program has included within the scope of their program. So I would suggest, and if necessary, resolve that we allow team sizes up to 5 people, because I think it would be logical. We're not going to have enough area. We're going to have too many members and not enough teams if we're going to limit it to 2 people. And I think family law is one where it would be appropriate to have a 5-person team on that, especially if we consolidate.
Okay, Steve.
Just a point of order there. Because we are actually creating a team, these teams by formal action, those teams themselves are then subject to Bagley-Keene. So it's fine to have 5, but then you're going to be subject to the notice requirements under Government Code 11121B.
Thanks, Brady. And thank you, Steve. So
can I ask one? I'm sorry. Can I ask one question about that, Brady? So the state bar is a licensing board. They're allowed to have closed meetings for planning purposes when there's subgroups within the meeting. Has that been looked at yet?
We've definitely looked at the closed meeting rules, and they don't apply to the meat of policy, which these groups are going to be working on.
Okay. Do you have anything else, Steve?
No, thank you for letting me interrupt.
Sure, of course. So I see Leah's hands up, then it's going to be Fariba, then a member of the public who has, I believe it's her hand up, Nina, and then Carolyn put her hand up. So Leah, you get to jump in whenever you want, so go ahead.
Okay, so Linda, I'm wondering if you can go back to the slides on children in custody and family, because when thinking about combining, we should have put them together. So I just want to call out the last 3, child protective services, dependency, and aging out of foster care. The last 3 areas that were included in children in custody in the Justice Gap study do not fall squarely within, I think, what folks traditionally think about when they're thinking about family law. Often those are actually heard in juvenile court by different judicial officers. So I'm putting a question out there as to whether or not the group might want to consider breaking children in custody and family up and pulling out child protective services, dependency, termination of parental rights, and aging out of foster care. And then Linda, if you could go forward to family. Similarly, if you might want to pull out guardianships as a question, but certainly elder abuse and DV. So when you say that you want to combine family, which I think makes a lot of sense, and initially that was our staff recommendation, but there's a lot of disparate pieces here that aren't like traditional families. So I'm wondering if you might want to have two teams, one that's doing family, child in custody, divorce, dissolution, child support, and one that's doing everything else. So that's a question that I have for you. And then with respect to employment, if you could go to the employment slide, Linda. There's a suggestion that it was dealt with in income maintenance. I think we dealt with unemployment benefits and income maintenance.
And workers' comp.
And workers' comp, but we didn't deal with all of these. So I would just say, I think there are other areas in employment to consider. And it may be that the team comes back and says, we don't want to do anything else besides unemployment and workers' comp. That may very well be the outcome, but I do think it's inaccurate to suggest that it's fully been addressed by the work that the income maintenance group has already done. So those were my comments, Judge Yu.
Thank you. And I see Steve's hand is up, but I'm going to go in the order with Fariba. And then I know someone in the public wishes to be heard, but I'm not sure if we've had a formal call for public comment. So we'll address that after we hear from Fariba.
Thank you. Hello, everyone. I was just wondering if the title of children in custody is a descriptive title. That is every issue that has to deal with where children are living and who takes care of them is the intent of this title. Then it would make sense to move foster parent licensing, adoption, and guardianship over, and then move child support to maybe something called other family, and then create another group for violence prevention, because elder abuse is not family law, welfare is an institution code. Civil harassment is in the CCP. And DV, of course, is in the family code. So, you know, the common denominator is violence prevention. And so if you group those in perhaps something called the violence prevention, then children's issues in custody visitation, and you have the traditional family law in this, you know, in the topics that are already mentioned, which is divorce and support, then it would probably make some more sense. And then later on, I'm assuming when we get to the training module, that is, we're looking at what training is needed, then we can address trauma-informed training, and that, you know, these paraprofessionals have to have that, and then children's issues training, versus if they're just handling divorce without minor children, perhaps they don't need that. So I'm just looking for some grouping that makes more sense like that from the perspective of, you know, discussing the expertise involved and necessary as well.
Thank you, Fariba. So Ira said, and I'm not sure if he is able to have us hear him, but he said he would like to have the public make their comments in the order of raising their hands, just like the members. But I understand that we do need to have a formal call for public comment. Let me ask Linda for a point of order. Can we do that interspersed with member comments, or does that come at the end of member comments?
It's been our general practice and to have a public comment period generally at the beginning, but it's technically at the chair's discretion, and we could certainly do it. We could do both, or we could just have the public raise their hand, given that that's an option as well.
Thank you, Brady. I think since Mina has had her hand up, and I think it's Mina Sirkin, so Ms. Sirkin's had her hand up, I'm gonna let her make her comment at this time. Ms. Sirkin?
Yes, can you hear me?
Yes, could you please talk louder though? We can't hear you very well.
Yes, just a moment.
Thank you.
I have a couple comments that are relevant to this. Number one is about housing.
Oh, Ms. Durkin, do you mind just also introducing yourself? Because I'm not sure the sort of perspective that you bring will be helpful to me to know what your area of practice is.
Yes, I'm a board certified specialist in probate, estate planning, and trust law.
Thank you.
I also handle quite a few elder abuse cases in my practice. So my concerns are as follows. I don't think that the elder abuse issue should be part and parcel of family law. The reason is elder abuse is often mixed with conservatorships, trusts, and estates. It comes into those areas. So if we excluded the trust and estates practice areas, from what I understood last time, elder abuse should also be excluded, because inevitably you can run amok of the elder abuse action if you have no knowledge of trust and estate cases or conservatorships and don't know how to maneuver between elder abuse and conservatorship and estates, because all of those merge together when there's a cause of action for elder abuse, especially with elder financial abuse. Number two is I am very concerned that you included under housing clearing of title. Clearing of title is a huge part of financial elder abuse. It is the area that has gone rampant in the last 5 to 10 years, because you have paralegals, you have LDAs who are producing deeds, and it's those deeds that end up causing the elder abuse cases. So I am very concerned that someone slipped that in under housing. Those are completely separate items. Clearing of deeds is a function that must include, okay, the issues of being able to see who's on title, especially when their assets are in trust, making sure that if somebody has a power of attorney, that they're not able to transfer trust property, things of that nature. So I think you need to take elder abuse out of that, and that needs to be discussed separately. And also with the issue of title clearing, there has to be major limitations put on title clearing because it is so broad. Gifting is title clearing.
Oh, and Ms. Durkin, I'm not sure if you were at previous meetings, but I think that you're on the right track, and we agree with you that title clearing is very complicated. So it's not, I agree with you in that regard, but I hadn't thought about the elder abuse issues with title clearing. So thank you so much for raising that. That's a really important point. Usually public comments are about 3 minutes. So would you be willing to sort of wrap it up, please?
I'm actually done. I said my 2 points regarding those matters. Those are very important areas that overlap, but I have nothing further to add. So I can mute out and just listen in.
Oh, Ms. Durkin, thank you so much for those comments. As I said, I hadn't thought about the elder abuse aspect of clearing titles, so very important. Appreciate your comments.
Thank you.
So next is Carolyn.
Thank you, Your Honor. And it might be better to pass and hear Mr. Fleischman. This is sort of the thing that I was trying to raise in the beginning, is that this is really substantive discussion. And we had a lot of information that was given to us in the first meeting, and we spent maybe less than an hour brainstorming on these areas. And then we went straight to the undecided.
Carolyn, sorry, what is your point? Because if we keep talking about sort of how you feel we haven't spent enough time, we're kind of not really using our time well. So what's the point you want to make now?
I think that if we're going to schedule, we schedule these issues. If we're going to make motions on things, it has to be done more slowly. I can't write as fast as everyone's talking. And I think rather than rushing the compilation of 30 different issues, it's got to be done with some kind of deliberation. So I think this may roll over into next month, and then we do presentations substantively in October and December. So I just don't know, unless we slow down today to really go through what areas. It's complicated. You can't just throw employment into income and maintenance. We spent a lot of time, Your Honor spent a lot of time talking about that. So my point is just, I don't know that we can do it today unless we go, we can try, but if everyone could slow down and go through what they're talking about to combine things, is a lot of crossover.
I totally understand, and we all process things in different ways. What I'm starting to wonder is it better for us to figure out how how to staff this. Like some may be fine with 2 people, some maybe need more, and then maybe it will be more clear that we can combine some things. But I do see Leah wants to say something.
Yeah, I wanted to say this issue of clearing title, that's exactly the kind of thing we would get into in the deep dive in houses. Housing is a wobbler. It's ready for the deep dive. We will have, you know, the ideas of facilitated discussion, including a judicial officer and subject matter experts, spend 2 to 3 hours with the full working group and really get into the weeds on what is clearing title, what is it all about? And you all will make a decision at that time. Should it be included? It is a funnel process, because just because something's included for now doesn't mean it's going to be included at the end of the day. So I think we could set aside the clearing title, and then for REBA, several folks have made recommendations about what to do with family and children in custody. And so I think to help us move forward, we might start with that and figure out what is the grouping that you all are most comfortable with, and then judge you the question, which of those require more than 2 people and which don't.
Okay.
Right? Because some might and some might not.
Yeah.
I would suggest if we start with that, it'll help us kind of move forward.
Yes, and I know we want to get through that funnel process, as Steve Fleischman said, but I still have Steve Hamilton, Julie Felmuth, and Steve Fleischman's hands. And after those comments, I think we can start to shift our perspective. So Steve Hamilton.
I just wanted to respond to some of Leah's questions after I spoke. The dependency law usually, even though it is in juvenile court, does come within the family spectrum. I think part of the reason that I wouldn't separate it out at in dependency court, whether you are a parent or a child, you have appointed counsel already. That's why I'm really curious as to how that got identified as a need area, because you get appointed counsel if your parental rights are going to be terminated. You get appointed counsel as soon as children have been taken into custody. So I think it's okay to leave that in family law now, so we don't start parsing out areas that are within considered in the family law spectrum. I wouldn't parse out domestic abuse either. Ironically, I'm just driving back from Chatsworth, where I just did a domestic abuse hearing. In some cases, there is no crossover. But in other cases, at the domestic abuse hearing, the court's going to make custody orders, the court's going to make support orders, and the court's going to make fee orders. So I'd be apprehensive about segregating out domestic abuse, but with the understanding and belief that when we deal with that issue, we're going to be reaching out to very specific groups that are engaged in that area of law, like the Family Law Violence Appellate Project. I do agree the elder abuse issue, if it's going to be considered, it should be considered in the civil forum. That is not a family law action, in my opinion. Thank you.
Thank you. So Julie?
Thank you, Judge Yu. I wanted to ask bar staff a logistical question about the Bagley-Keene Act. In normal times, you don't want to have more than 2-person groups, because that does trigger the notice, agenda requirement. It requires staff to find a room, lots of other logistical stuff. I wanted to ask, in this era of Zoom, is that really a big deal? So let's say we do have 5-person teams, other than just finding a time when all 5 people can meet, isn't that a less bigger deal than in normal times?
I'd like to respond to that. The challenge isn't so much in finding a space, like a room. The challenge is in identifying people's schedules and setting, if we have to have a sequence of meetings. So for the wobbler teams, we had a series of meetings, and oftentimes we would say, are you available? And people were available within a few days. So if we're to comply with Bagley-Keene, a notice has to be posted 10 days in advance of every meeting, whether it's an in-person meeting, a phone meeting, a Zoom meeting. And so it is possible to do it. But what I think would have to happen is, as soon as we identify the teams, we'll have to set a series of meetings that are at least 10 days out. And so it can be done. It just becomes more challenging, especially if you have a group of 5 people, to set a series of meetings. And then to ensure that whatever experts we want to bring in are available on the dates that have been set for those meetings. That's the challenge. It's not
Right.
insurmountable, but it is a challenge.
Thanks.
Thank you.
And then there's two more hands, Stephen Fleischman, Ira. I saw Dana's hand up, but now it's down. So that might have answered the question. Stephen Fleischman?
Yeah, real quick on the family and child custody issues, I'd prefer for us not to get into those issues today. I'd rather just appoint a committee, let them analyze the issues and decide if they want to break it up further and have a separate subcommittee. I'd be fine with that. I don't think it's productive to have that discussion though today.
Okay, and Ira?
I think it's important that we focus on what are our criteria for grouping things together or not grouping things together. I don't think we've discussed that, and I've heard a few different rationale criteria given, like adequate staffing on the part of our working group. In other words, enough people to fill each one. Overlap in the people who we will consult, the experts will consult, what kinds of cases are heard in which kinds of courts, and a number of other reasons. But I think we ought to be clear, if we can be, it's a little tough, I think, about what are the reasons we would group things together.
Okay, thank you. And then I just want to make sure Dana didn't want to say anything. Her hand was up and then it went down.
Thank you, Judge. I was just going to point out that in the dependency realm, it's income-based, whether you get appointed counsel.
Oh, that's interesting because in some counties it's not so much income-based. Our parents get the counsel.
Yeah, it is. Since Linda and I both worked on that project for many years at the Judicial Council, we do provide appointed counsel in California, one of the few states that does for parents. But if you notice in the slide on children in custody, the asterisk was not on, if you go back to that slide, Linda, it was not on the children in custody, Linda, the other slide. Not dependency, termination of parental rights. It was on child protective services.
Yeah.
The right to counsel does not latch or attach simply because you've had a child protective services complaint filed against you. So it may be that these are the folks that precede the juvenile court process when counsel is appointed, but instead, and I do think it's interesting, this overlap with family again, because we do know that sometimes in contested custody matters, you see lots of calls to CPS from the parents. But anyway, I thought that was interesting. That's where the asterisk is, not dependency, termination of parental rights, where we are providing appointed counsel in this state.
Okay.
Yeah.
Thank you, everybody. So I think we should try to start shifting using our time. We have about an hour and 10 minutes left. So we want to be productive. And I think we went to Brady, who talked to us about whether we need to have two people, and we kind of interrupted Linda and the presentation of the PowerPoint. So I'm going to go back to Linda.
Thank you.
Thank you.
So just to put in context the decisions that have to be made today, what we're looking at is for the remaining meetings, what we're proposing is that at the August meeting, that the groups that undertake the Wobbler process with regard to family, consumer debt, employment, and children in custody would report back at the August meeting with the recommendations for the subtopics to be included. And then the second half of that meeting would be the deep dive into one practice area, and that would be subject to discussion today and decision today. And then in October and December, to use each of those meetings to do a deep dive into up to 4 practice areas. So 4 in October and 4 in December. And the reason that we're splitting it up this way is that we have 9 altogether, unless there's a decision today to merge some together. Right now we have 9. So if we take on 1 in August, then we're recommending doing 4 in October and 4 in December. And then using the February meeting based on the decisions that were made at the deep dive, use the February meeting to determine the licensure and certification process for the areas and the specific tasks that were identified at the deep dive meetings. Use the April meeting to talk about a regulatory model, including metrics for evaluating the program. There's been some discussion about where the regulatory body, who would be responsible for regulation. And then talk in June about rule and statutory changes. And at that point, we would bring in our Office of Professional Competence, which has, through ADLs, identified some rules and statutes that might be changed, but we would need to do a very lengthy discussion about the specific rule and statutory changes that would need to be recommended. And then use the August meeting to talk about how we would ensure that a paraprofessional program is successful, with looking at increasing awareness for the public, as well as increasing awareness for potential paraprofessionals that this is an available route to practice for them.
Linda, when would the final report be drafted?
So the final report will be drafted in July. Well, it would be drafted earlier than that. So moving on to this next slide. Well, what the roadmap shows that in September, we would make a presentation to the Board of Trustees with the concept recommendations and the practice areas, for the practice areas and tasks that the working group has identified.
Linda, can I jump in?
Yes.
Because I think, so to answer the first question, the idea is that you all would be able to review the draft of the final report prior to the August meeting. So the August meeting, in addition to talking about marketing and awareness, that would also be an opportunity to identify edits and changes to the final report. That process, from our prior experience, can be very messy. And so it may be that we would have to schedule a follow-up call like this one to really nail down the final report, but you will see it prior to the August meeting. And then with respect to this slide that's up, the top of the screen was the original schedule with respect to the points at which there would be presentations made to the board. The bottom section of the slide shows you the revised proposed schedule. So we now are not recommending that this group provide any update to the board until January of 2021. But at that time, you would be able to give the board, all right, here's the list of practice areas that we've agreed upon, including the sub areas and the tasks. And that would be the update in January, and then the final report to the board at its meeting in September, its planning session.
Okay, and since we interrupted you, Linda, I do see Amos's hand went up. Amos?
Thank you. So I very much appreciate all the work that's going into selecting practice areas, and it looks like we're going to be doing that for a while more if we have deeper dives on each of these. I don't necessarily object to that. I think it probably could be streamlined and we can maybe narrow down the topics and not do deep dives on all of them. But my real concern is that in looking at the roadmap, I think it's really essential that this working group spend significant time, appropriate time, and maybe deeper dive type in-depth discussions and facilitated discussions on the ensuring public protection, the consumer protection issues. And I think that could go well beyond, I think, what's scheduled right now. We're spending so much time on practice areas, but I think we really need to identify what this would look like and what kind of protections are in there. So what I would recommend is that we do try to streamline the selecting practice areas. I think at the end of the day, we're not going to want to propose 5 or so areas. We're probably going to want to pick 1 or 2 or 3 to propose. So I'm hoping we can maybe streamline the selection of practice areas and really make sure we build in time to talk about ensuring public protection.
Okay, thank you. Go back to, oh, sorry, Leah, you want to say something?
Well, I will say that when Linda and I worked up this schedule, if you could go to the previous slide, Linda, we did talk about that there is going to be a need to start on competencies and pathways for licensure and the regulatory model well before the meeting dates, that these would require the appointment of committees of this working group, and our own staff recommendation would be that these be larger than 2 people. So they would be subject to BK. So perhaps a group of 4 or 5 working group members beginning to work on these issues later this year. Just to your point, that I think it is a tremendous amount of work. And the only thing I would say in terms of having a mind to limit the number of practice areas, that there's a tension between that and ensuring that you are creating a viable business model. One of the challenges that we saw, for example, in Washington, or one of the challenges I've heard, is when the approved scope of what these paraprofessionals can do is too narrow, that has an unintended negative consequence on the viability of the business model. So just something for you all to consider when thinking about the number of approved areas.
Okay, and then Julie, you want to say something?
Yes, thank you, Judge Yu. I had a quick comment. I'm assuming that most of the people who applied for this paraprofessional license are going to be paralegals. They will have gone through a paralegal course or a paralegal school. So I'm interested in knowing, because I don't, what is taught in paralegal school. And I don't think under the current or under the revised roadmap here on page, well, it's the second to the last slide, we probably wouldn't get there until February of 2021. But to me, knowing what is taught in paralegal school might inform our decisions as to what practice areas we should be choosing. Just a comment.
Thank you, Julie. Okay, Linda, back to you. Oh, actually, I see another Julia Brennelson says she could speak to that. I think that was the issue raised by Julie Felmuth.
Yes,
go ahead.
I would like to speak to that because I've been teaching in paralegal school for 15 years. And we are the only community college outside of the Bay Area in Northern California that has ABA approval. So that it makes it, and I guess one of the reasons I want to say that specifically is if we want to generate interest in this licensed paraprofessional, is we need to, I believe, really focus on how could community college serve and teach this paraprofessional what to do, because there are expensive and nice private schools. And there's a smaller one 1 mile away from where I teach. But they are a private school that it's got prohibitive cost, and it's, I think we really have to think about how could community colleges do this. I am very happy to speak about the curriculum that we have. We just obtained reapproval this last year by the ABA, and it took us 5 years to receive our initial approval by the American Bar Association. And it was we had to do a lot of different things to change our program in order to equip it so that it would meet their expectations and approval process. So a lot of that has to do with what the required courses are. So you have, for example, Introduction to Law in the American Legal System, Legal Research, Legal Writing, Civil Procedure and Litigation. And so those are the main required courses to obtain your paralegal certificate or your AA in paralegal studies. So then you have to select from your elective courses, and we teach everything from, for example, this summer I'm teaching advanced legal research and writing, which includes e-discovery, and I bring in technology folks.
Julie, I'm so sorry to interrupt. Can I ask a question? Because I think this is helpful, but I also, I wanted to ask more of a direct question. For the different subject matters that we've discussed, like family, civil, employment, are all those topics touched upon or available in a paralegal's curriculum?
I will say the only one that is not, for example, at our college is employment law.
Okay.
We have family law, yeah, we do, and then we also have an expungement clinic. So we are running an expungement clinic. I think it's 3 times a semester.
Wow, that's amazing. Thank you so much, Julie, for raising it, and Julia for sharing. I'm sorry to cut you off, but
no
I
problem.
We'll get more information from you later. I'm just mindful of the fact we have less than an hour left now.
Yeah.
And I think Elizabeth would like to add, if you would do that, Elizabeth.
Can I say one thing though? I think it is important to note that we do not have employment law even as an elective. I don't know how many paralegal programs do. So I guess what I'm saying to you is, I think it may be helpful to have an analysis of this. Is that even naturally included in any other paralegal program? Because if it's not, you are not going to have paralegals coming in with paralegal training to now apply those skills in an employment law paraprofessional program.
Right, unless they got it in work practice.
Exactly.
In a firm that does that.
Or in law school. I mean, I think part of that pathways to licensure for this group to talk about will be all of the different types of folks who might be interested. So paralegals certainly, LDA certainly, but you also have a lot of people who have completed law school and who have not passed the bar.
Correct.
So I think you've got different groups, and that will be part of that whole conversation, which again, I echo Amos's comment that this is going to be like a very significant topic, and why I think there will need to be a subcommittee of the working group focused on it, you know, beginning later this year.
Yeah, thank you. And Elizabeth, a comment before we move on?
Yeah, just quickly, I just wanted to mention that I know that the paralegal schools train people to specifically work under the supervision of an attorney. So any education component that we create should have how to run a business, well, when you're working directly with the public and the consumer.
Ah, that's a super good point.
That's all I wanted to mention.
Very good point. Thank you, Elizabeth. And sorry if you felt rushed. I'm sorry about that.
No.
I want to get us to the conclusion and have something that we can go off on. So let's see, Linda?
Thank you. This is the last slide on the slideshow. And so I think just going back to here, I think this is where we are. We need to decide, I think maybe the first decision should be the sequence for the practice areas to be on the August to December meetings. So to discuss whether there's agreement that we want to have the subtopic groups present at the August meeting, the ones that are going to apply the Wobbler process to the children in custody, consumer debt, employment and family. If there's agreement that will be the first half of the August meeting, and then a deep dive would be the second half of the August meeting, and then what specific topic would be included in that August deep dive, and then what topics will be on the October and December meeting deep dives.
Okay.
And then secondly, to determine who will take on each of those tasks. The main thing is the team composition for the Wobbler practice areas.
Yeah. Do we have a sense that perhaps it's easier to pick it might be more streamlined to pick the easier topics and put them in August, so that the more weighty topics that might need more talking to other people would be presented later? Is that is that a lens we should use in looking to answer this question, or is there a different way to look at it that might be more efficient?
I think that makes a lot of sense to approach it that way.
Okay. Does everybody else think that's okay? You can put a thumbs up if you want to.
I'm a little unclear, and sorry, Linda and I are exactly tracking here, but I'm a little unclear what that means, because the idea, I think we do need to come out of the August meeting with the final set of practice areas that are being considered. And so that would require children in custody, consumer debt, employment, and family all to come forward in August. In addition, there was room, we thought, for one area to have a deep dive. That could be housing, it could be collateral criminal, it could be general civil, one that's already been kind of worked up at the subtopic level. So I think we do, to kind of move it forward, need to get through children in custody, consumer debt, employment, and family at the August meeting. And some of those might come off the table altogether after August, I don't know. And name and gender change. So I do think that's important for August, to kind of keep the process moving forward. And then do a deep dive into one of the subjects that's ready for a deep dive.
Okay, so I guess we're at the point where we need to decide what's going to be consolidated and what's not going to be consolidated, and how we're going to recast children in custody, if we are going to, etc.
Yes.
So I've heard a lot of different discussion points, and we do have some hands up. So a couple more comments, and then we need to start making some decisions. Carolyn?
Okay, real quick, my main question was, what is the difference between a deep dive and then what we just did with the wobbler things? What is specifically, because I know Leah mentioned judges and lawyers, but can you be more clear so we know?
So what we're talking about for the first half is applying the wobbler process to this children in custody, consumer debt, employment, and family. So that it would just be to determine which subtopics, if any, like we saw with veterans was taken off the table after the wobbler process. And so it would be a wobbler process, the same process of determining subtopics, or a recommendation just not to include that particular practice area at all, for each of these four that did not undergo that process yet. And
okay,
so then after we complete that for these four subject matter areas, these practice areas, then we would do the deep dive for all of the practice areas, including those four. So those would come back for a deep dive after that first process was undertaken for them.
And the distinction, Carolyn, to just get really tactical, it would be that you would have the sub area as well as the tasks. And so to, I think, a point that you've made previously, in some places, the wobbler deep dives did get to tasks, because we did get to things like representation in court. That's actually a task. It is not the sub area. It's, you know, within the sub area of enforcement of judgments, what are the actual tasks that a licensed paraprofessional will be authorized to perform? So the goal of getting to the end of the deep dive process for all of these topics is we have the subtopic area and we have the approved activities or tasks, because it is at the approved activity and task level that you really create your licensure program. And so that's why you've got to do both. And again, some of the wobbler subcommittees did get to tasks. So it's a little artificial trying to keep all these things bifurcated. And I think we have to acknowledge that. But at the end of the deep dive process, that's what you'll have: sub areas and approved activities. And then you're ready to create your licensure and regulatory framework.
Okay, just one more comment. I would just, if we're going to do it that way, because I did not understand that's what we were doing the last time. And those resolutions came out of the recommendations the Friday before the meeting on Tuesday. So
Carol,
if we,
what's the point though?
well, Your Honor, this is the next one. Yeah, very quickly. I think if we do it this way then, and we take these 5 topics that were in the quote unquote in column, then, and then we're doing an area, subtopic, and tasks recommendation that's going to go to resolution, I think then in August, we need to see those resolutions in advance of the meeting. a goodly amount of time in advance of the meeting because we're making big decisions there. And I won't get a chance. I don't know if we're going to be able to serve on more than one committee. So for those of us who don't get a chance to understand the resolution, I want to make sure people have a chance to do that when you don't get to see the report until the Friday before the meeting or 3 days before the meeting.
Okay, thanks, Carolyn. And I really appreciate that you asked the question about what's the distinction on a deep dive, because I think it really clarified it for me. So it's a good question. Thank you. And then another comment is from Ira.
I'm questioning in my mind why, whether we should have a deep dive in the August meeting, because I'm questioning whether there's enough time to do what's planned for the first half of it.
Well, as a leap of faith, there may be time to do it because one of the groups might be able to get there. So let's just try to figure out what we think is standalone. So health will be standalone, right? So we can knock that off. It's not going to be consolidated with anything else. Is that correct? Everybody agree with health is on its own? So nobody's saying no. Don't see any. Oh, I see a hand. That's Ira, but his hand he already spoke. Okay. And then housing, is that standalone? Understanding that the elder abuse issue with the clearing title is, there's some crossover, but is that sort of pretty much standalone with keeping in mind what Ms. Sirkin said? Anybody object? Okay, so then we're at consumer debt. I heard Steve Fleischman say that he thought that could go under civil. Do we think that's a good place for it, or do we think it should stand alone?
I thought it's already under civil. We have recommendations in general civil that for consumer debt, paraprofessionals be allowed to represent debtors, not creditors. We had a debate about general jurisdiction versus limited jurisdiction. We had in-depth discussion about judgment debtor exams. I think it's there.
Linda, can you go back to the slide from the Justice Gap study on consumer debt just so we can see what exactly was covered?
And Fariba, I do see your hand. So after this point, I'll come to you.
Here it is. So Steve, do you think all of these are covered?
I think many of them at the end of the day are. I think most of them fall under the heading of pre-litigation dispute that I'm not even sure is the practice of law. Bankruptcy, we're going to have the same problem that we have with veterans, that the state bar isn't going to be able to regulate what happens in federal court. Most of the rest of these are pre-litigation matters that I'm not even sure. Like I said, I'm not even sure, credit repair, you see all sorts of that, 1-800-FIX-MY-CREDIT. I'm not sure that's practice of the law. If you're saying you want to do it, have the general civil committee look at all these things or have another committee, I think we're biting off way more than we can chew. I think we just fold this into what we already decided on general civil, and these specific things go away.
Well, after consideration by the group that looks at it, because like you said, bankruptcy may be looked at and then relatively quickly resolved.
And just to clarify,
yes,
all of these topics were not identified as areas of greatest need. It's just the ones with the asterisks. So they're all listed because these were the types of questions that were asked in the Justice Gap study, that under this category of consumer debt or financial issues, the ones that were identified as those with the greatest need were unfair lending practices, harassment by a creditor or collection agency, and utility shutoffs.
Okay. I'm going to make a suggestion that just based on your comments and Stephen's, that I think this does need to be looked at between now and August. It could be the same group that did general civil the last time, which was more than 2 people, because certainly the recommendations from the general civil group should be considered by any group looking at consumer debt, because there is overlap. So we don't want to pretend like work hasn't already been done. But I would suggest that maybe there does need to be a group, and maybe it could be the same people, and rather quickly you could get through it because you know exactly what you decided already.
And what we heard from the people we talked to.
Yeah, what do you think about that, Stephen?
I'm fine with that, but as I recall, general civil was just me and Erica. It was income maintenance that.
You're right. I'm sorry. Okay.
Well, this is Carolyn Shining. I wanted to be involved in general civil, but I guess the 2-person rule was not applied. So if there's a way, again, to get those things in advance, what is discussed, so that people who are not on that team can respond, because the vote is going to be a serious one.
Okay,
And I don't.
We heard that, Carolyn. We're running out of time. I think Fariba had her hand up. Do you still have your hand up, Fariba?
No, what I wanted to say was already discussed. That's fine.
Okay.
Thank you.
And so I'm hearing that you can be part of this, Carolyn, if you want to, because the 2-person rule was followed with general civil, but Leah is saying it might be if we put consumer debt into general civil, we would be able to accommodate a larger group. Did I hear you right, Leah?
No, I thought the general civil group, I've got general civil and income maintenance mixed up. Any group can be larger than 2, but it will trigger the BK requirements. That's totally up to you all.
But do we think consumer debt should be going with general civil? I think
that team should review it. My 2 cents.
You're saying that general civil team should review it. Yeah. Right. So it should go with general civil.
Yeah.
Okay. Does anybody disagree?
I so move.
Does anyone disagree?
I would, Your Honor, I would just add that if there's a way to get that information in advance, sufficiently in advance of the meeting for myself and maybe those people who are interested, so that I could respond if necessary.
I'm sure we will do our best. A lot of the groups were able to get their reports out earlier. Ours was held back because we couldn't resolve it, and we had to have various different representations or recommendations. So I'm sure all the groups will try. And if we could please not plow the same things you said before, because we're running out of time, let's just kind of say new stuff and move on. That's what I always tell my lawyers in court. Anything new so we can move on. So anybody disagree that consumer debt should go with general civil? Okay.
Yes, I do.
Okay, go ahead, Ira.
There's a whole lot in consumer debt here, and a lot of it is outside of a court, but there's a ton of things that happen outside of a court that are the practice of law. And I think this is way too much for one group of 2 or 3 people to consider. I think there ought to be a separate group for it.
Okay, thanks. I think you and Steve agree in some that we are biting off a lot, but let's move. Can I see that slide where we're trying to decide what goes with what? Thanks, Linda. Okay, so do you want us to vote, Leah and Linda, on how we configure these, or is it by consensus?
Yeah, it's by this. We were thinking could be done at the chair's prerogative after getting all of the input of the group. If you want to entertain a motion from the group to vote on it, I think you can do that also. I was hoping there would be general agreement about how to proceed. I think to make it really clear for right now, like when we're talking about consumer debt, I would say the question is, there will be a team to look at it between now and the August meeting. Is that team the same 2 people who looked at general civil, or is it the general civil 2 people plus others? And Ira, I think you're suggesting it would be plus others, which again is fine. It just triggers the BK requirement. And so maybe to move it forward, if people are comfortable with that construction, then we're just deciding whether or not it's more than 2 people, and if so, who wants to participate.
Okay, so I won't ask for a motion yet on that one. Then what do we want to do with children, custody, and family? Who would like to be heard on that, if anything? I think mine, go ahead, Steve.
My view is combine them, appoint a committee. That one, I agree with Steve Hamilton, justifies more than 2 people. If that committee decides to break it up later, fine. But let's get moving on it. That's a big one.
And basically they could make their own subcommittees to do their own investigation and report back to their larger committee. Is that what you're thinking?
Sure.
Does anyone want to?
Stephen Hamilton, yeah, I was going to say that would definitely work, because then as long as we kept the subcommittees of the subcommittee at 2 or less, then the subgroups wouldn't have to be subject to Bagley-Keene.
Yeah, and then Fariba has her hand up. Go ahead, Fariba.
I was just gonna repeat that. I think they also should be collapsed together because there are a lot of crossover in everything. I mean, even in civil harassment, where you got the new girlfriend and the wife going at a visitation exchange, boom, we got custody visitation issues. So I would agree that it would be one category of all those things. I'm not sure if it should be called family or custody visitation because, you know, different areas of law are involved, but definitely one group.
Okay.
I doubt it.
And then what about collateral criminal? Can that stand on its own?
Yes.
Yes? Okay. So then
Yes.
that leaves the areas about merger with income maintenance and family. Sorry, income maintenance and employment.
I recommend employment just get folded into the income maintenance group. There are 4 people. There's a wide divergence of views. It's a very balanced committee. If someone else wants to join, I'm fine with that. I have no problem complying with Bagley-Keene. And while I agree with Leah that there's not 100% overlap, there is significant overlap and subject matter expertise in that existing committee.
I'm going to follow that precedent just now. And Steve, no offense, but I wish that everybody in this call would follow the rule about raising your hand first and not just talk.
Okay, thank you, Ira. And Sharon did have her hand raised. So Sharon.
I would just, I'm not sure how I feel about the merger, but I would say that income maintenance is more than just UIB benefits. It's more than employment. You have to consider Social Security, so SSI, SSDI, TANF benefits, other public benefits. I kind of see it as a Venn diagram, some that overlaps with health and some that overlaps with employment and even VA benefits. So just something to put out there.
Thank you, Sharon. And then Carolyn.
Okay, thank you, Your Honor. Okay, so on employment, I would slightly disagree with what Steve says. I think wage theft is something that the income and maintenance people did not consider. And that could be moved into, that's Department of Labor. That's a fairly obvious category to think about. But the workers' comp was already considered, employment benefits already considered, so they don't have to move them. Everything else on here is civil. Is important civil and big civil and very, very expert civil. So I would suggest that we get rid of completely and narrow the funnel right now on unsafe working conditions, unfair termination, failure to accommodate disability, and sexual harassment or intimidation. Those don't need to be considered any further. And doing any kind of dive on them, whether it's a deep dive or a simple, discussion with judges like we did, is going to waste this committee's time. And we got a lot of stuff to get to. So if we just move wage theft, we include 2 are included. Everything else I think should be just done with today.
I make a motion to adopt Carolyn's recommendation.
Can we see the slide with the employment issues, please? Thank you so much. Okay, so right now it sounds like Steve has made a motion to eliminate wage theft from any further consideration on employment. Is that the only thing, Carolyn?
No, that's backwards, Your Honor. Wage theft could go to income maintenance. And then workers' comp and unemployment are already in income maintenance. We don't have to do any more work on them before a deep dive. And then the rest of the categories, all of them are general civil litigation. And so those should be excluded. Right now, let's narrow the funnel.
I guess I need clarity on the motion then, please, Steve.
The motion is to eliminate unsafe work conditions, unfair termination, failure to accommodate disability, workplace grievance ignored, and sexual harassment. Wage theft, workers' compensation, and unemployment benefits would go to income maintenance, where 2 of the 3 already exist.
And those that you mentioned would be eliminated at this point, and there'd be no further consideration by any small group. Is that correct?
Correct. That's what I understood Carolyn to be advocating.
Okay, is there a second?
I second.
Okay, let's have
Oh,
discussion.
you can I second is that my motion or Steve's motion?
Steve made the motion, you seconded it. We're on discussion. Does
Okay.
anyone wish to be heard on this right now?
I am not a working group member, but I would just say that we're eliminating from any consideration the top 3 needs identified within this category, and employment was one of the top 3 needs regardless of income in the Justice Gap study. So I guess I would just caution taking them off the table without at least having a vetting by a team or a subcommittee.
Anyone else wish to say anything? Ira, you raised your hand, but
Yeah.
go ahead.
Yeah. Maybe I don't understand. I unemployment and a couple others that Steve mentioned are already accepted. Is that right? For further consideration, accepted with an A, and others are going to be dropped.
Well, right now, I think Carolyn and Steve are thinking we can funnel things further. I'm trying to get discussion. I'm not seeing a lot of people jump in, so I'd like to just add my discussion point, which is I personally don't feel comfortable taking things out without having some due diligence. I know it's a lot to do. We're going to be really good friends by the end of this process because we're all working together on this for, over a year, probably by the end of this. But I think we need to just, in my personal opinion, spend whatever time that might be even a small amount of time just considering it and giving everything due diligence. I feel like that means that we'll have integrity to the system. Everything gets a fair shake because at some point we're going to have to possibly explain what our processes were to the Board of Trustees and to the public. And if we are really appointed by me, the Judicial Council, and others by whomever we've been appointed to really look at access and fairness and the needs of people who are suffering because they cannot afford attorneys, I just feel like we should not give things short shrift, and we should at least give it some due diligence. But that's just my own personal perspective, and I'm not talking about here. Does anyone have any further discussion? That looks good. Does anybody else have any additional discussion?
Well,
Okay, so shall we call the question? Okay, so I'm going to ask if staff can help us please count the vote on the current motion. Does everyone have the motion in mind?
no. Can I hear it again, please?
Yes, Steve Fleischman.
The motion is to eliminate unsafe work. I need that screen up.
Yeah.
Yes, please.
I think Linda was going to try to type the motion. I think that's what she was going to try to do. But Linda, why don't you put that screen up and I'll type it up real quick.
Thank you. Oh, perfect. Great. Thank you. Is that a correct statement of your motion, Steve Fleischman?
I have to look at the slide to answer that question.
Oh, sorry. Let's see if we can get that slide back.
Oh, I'm sorry. I thought I had, I had put it, okay. I can't show both at once. So let me.
What?
I was trying to type up the resolution based on the.
Thanks, Steve.
Hold on a second.
Okay.
I think you need to include failure to accommodate. I got the slide up on my laptop. Failure to include accommodate disability.
Let's just get the slide up because Steve has asked for the slide.
Me too.
And Ira would like the slide. Okay. Go ahead, Steve.
The motion is 1, to eliminate unsafe work conditions, unfair termination, failure to accommodate disability, workplace grievance ignored, and sexual harassment. 2, to move wage theft, workers' compensation, and unemployment benefits to income maintenance.
Okay, so is that motion clear for everybody? That motion's been seconded and there's been discussion. Any further discussion from anyone?
Yes, I agree that with what you said, Judge, we shouldn't be dropping things. It seems a little precipitous right now.
Okay, any further discussion? Okay, so we're ready to vote, and I'll ask staff if we could please do a roll call vote.
Sure. Bashan,
No.
Bernelson,
No.
Falmouth,
No.
Fleischman,
Yes.
Hamilton,
No.
Hartston,
No.
McRae,
No.
Olvera,
No.
Shining,
Yes.
Sarouche,
No.
Spyro,
No.
and Judge Yu.
No. Okay, it looks like it's 12 to 10, if I count it correctly. Is that confirmed?
That is confirmed.
The motion does not carry. So what I'm going to ask for is an alternative motion that we have health, housing, and collateral criminal be considered to be separate groups that we will populate with 2-person teams. I think that's the consensus of our discussion. Is there such a motion?
Judge, I'm sorry, just to clarify, I don't think we need 2-person teams for health, housing, collateral, criminal, because we already you work those up during the wobbler process. So those are
tasks.
Dive. The tasks will happen during the deep dive sessions at the meetings.
Oh, we do the deep dive, all of us together.
Once you get to the deep dive, once it's deep dive ready, I think you can do it all together.
Oh. Okay.
Dive ready is like housing. You said unlawful detainer and clearing title. So now at the deep dive, you'll get into what does that mean? What does that entail? What are all the tasks? Do we think these are because we've narrowed housing way down. Now I think you can do it at one meeting altogether is my thought.
Okay.
If you guys disagree, you can create teams for all of these.
What do you guys think? I'm worried that with all of us together, it might be too time consuming to do deep dives on health, housing, and collateral criminal, but maybe we can. What do we think? I think we're getting tired and we are running close out of time. Go ahead, Aspira.
There's an uncertainty in my mind about that. I guess I'll ask Leah, saying that the deep dives are done all together, does that mean that the study is done all together, or that the decision is done all together, or both?
Well, I think we contemplated both, and so maybe it's a faulty model, but the idea is, let's just take housing because it's fairly simple. You'd have a judicial officer and some subject matter experts that would participate with this group. And to prepare for the meeting, there would at least be a task delineation. And we could even get, for some of these practice areas, we could get it from CAPA, the job analysis study that was just done last year. We have a lot of breakdown of tasks. And then you'd come and you'd say, all right, an unlawful detainer, here's the 19 things that are involved. Some of these happen in the courtroom, some of them happen out of the courtroom. And you'd start as a group to say, okay, of these 19, these 8 off the bat, we think that's perfectly appropriate for a paraprofessional to do. These 5 we're really unsure about, and let's talk to our subject matter experts that are here. Like, what do you think? Is this appropriate? What would it look like if it's a
Okay, Leah, thanks. I think we got the idea. Sorry, Amos has his hand up and we've only got about 20 minutes. Amos?
I would like to make an alternative motion. My motion is that we combine employment and income maintenance and assign that to the team that previously did income maintenance and invite other people to join if they so wish.
Okay, thank you. Is there a second to that motion?
I'll second it.
All right, thank you, Julia. Any discussion? If not, then could we please, I don't know, do we want a roll call vote or can I just say, does anyone disagree with what Amos just stated?
I think we're required to have a roll call vote since this is a Zoom meeting.
Okay, so then let's have a roll call vote. Does everyone have the motion in mind? It is to combine income maintenance with employment, put the same 4 people who had previously worked on it, and then add whomever wishes to join. Okay, let's call for the vote. Roll call vote, please. Thank you.
Araya, can you do a roll call vote for that?
Is she still on?
Hello? Yeah, I wasn't sure why my mute wasn't unmuting. Bashan?
Yes.
Bernelson?
Yes.
Falmouth?
Yes.
Fleischman?
Yes.
Hamilton?
Yes.
Hartson?
Yes.
McRae?
Yes.
Olvera?
Yes.
Shining?
Yes.
Sarouche?
Yes.
Spyro?
Yes.
And Judge Yu.
Yes. Thanks, Amos.
Thank you. And motion carries.
Good. Thank you, Araya. Is there another motion? We're looking at children in custody and family. It's being combined.
I'm on my phone, so it's hard to raise my hand, but Stephen Hamilton, I'd like to make the motion that we combine the issues of child custody, visitation, and family law, and include with that guardianships, but that we also remove elder abuse, and that should be moved over to the civil team.
Does anyone wish to second that motion?
Second.
And the second was by Sharon, I believe. Okay. Any discussion? Okay. Are we prepared to vote? Looks like, okay, Araya?
Could you, I'm sorry, could you restate the motion?
Oh, yes, I'm sorry, Fariba. I believe Steve Hamilton's motion was that we combine children and custody and family into one group, and with the exception that we're removing, what was it that you were removing? Elder abuse.
Remove elder abuse and add in guardianships.
And add in guardianships, and elder abuse would go to civil.
Correct.
Did I miss discussion? Because I didn't hear the last part of his motion.
Sorry, the motion was to combine.
I heard the motion, but I have a comment to make about removing elder abuse to civil.
Go ahead.
I oppose that portion of the motion because we're still talking about something that's absolutely nothing to do with civil. I mean, we've got violence prevention here. We've got sometimes husband and wives file for elder abuse instead if they meet the age requirement instead of DV. So we're looking at DV. And this also involves dependent adult abuse. So I just don't see how it belongs anywhere in civil. Is there a better place if you don't think it belongs in this arena? Is there a better place we could fit it?
Maybe, could it be spun out to its own category? Do we have 2 people on this committee who feel strongly and feel they have expertise in the area of elder abuse?
Where is civil harassment right now? Is that anywhere here?
It was addressed by the General Civil Committee, and at the last meeting it was recommended to be included as part of the general civil, as one of the general civil subtopics.
And that again is problematic because it's
Maybe
just,
I'm sorry, Sabrina.
I'm sorry, I don't mean to go on, but I just think we need to understand that we're talking about violence prevention. We're talking about a lot of crossover here. So I just don't think they should be lost in general civil.
Sorry, go ahead, Steve. Say, and then I'll jump in.
I was going to say, hey, Fariba, I would take a friendly amendment, but I want some advice from you. Do you think we should put civil harassment and elder abuse together in their own category, or do you want them kept within family law?
I had suggested, first of all, at the outset, I think we can discuss it in group and decide what we're gonna do versus this group. Second, I think that I had suggested early on in today's meeting that I think having a category called violence prevention may be helpful here for DV with no minors, elder abuse, and civil harassment. I think Steve Hamilton, you mentioned earlier with the crossover of DV and custody visitation, you're 100% correct, of course. So I think if this group feels it's better to just leave it in family and discuss it later, I would hope that we can move civil harassment here as well in this group, and then discuss whether we should parse those 3 categories I mentioned out to its own group, or today do that. I really would hope that we make one of those.
Thank you, Fariba. I
Thank you.
see Amos's hand, and I'm gonna just make a comment as a member of the committee, and then also want to hear from maybe Karen, and after we'll go to Amos. If you wouldn't mind muting, thanks. Having done the civil harassment calendar, and maybe because Fariba and I are both from Santa Clara County, I actually agree that it makes some sense to put civil harassment in with family. The reason why I'm thinking about it is that way is, you know, the self-help center, people are working on all those issues in the violence area. And so if those people are on that, in that working group, it might be better than splitting them off. So that's just my comment. And Amos, what did you want to say?
Yeah, so I'd like to make a friendly amendment to leave elder abuse in family law and to move civil harassment from general civil to family law. And I'll, with the additional comment that I think probably next for discussion is to combine general civil with debt collection. So I think these issues probably fall closer to the family law umbrella.
Okay, Steve, would you accept that friendly amendment?
I do.
And would the second accept the friendly amendment?
I do.
Okay, so the motion is to move children, custody, family together, keep elder abuse in family, and move and add guardianship and move civil harassment to that group. And then they can break down to subcommittees and work separately. Is there any further discussion? Okay, I think we're ready for a roll call vote.
Okay. Bashan,
Yes.
Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Shining,
Yes.
Farouche,
Yes.
Spyro,
Yes.
and Judge Yu.
Yes.
Thank you, and the motion carries.
Thank you. Amos, you had a motion, I think, with consumer debt and civil?
Yeah, I think, well, I'll make my motion to be to combine general civil and consumer debt. I think now, especially with these changes, there is a lot of overlap, or at least a lot of relationship between what's next, what is left, and we might want to bring up general civil so everyone can see what's left in general civil.
So that's your motion. While that's being brought up, is there a second?
I'll second that.
Thank you, Julia. Now, any discussion? And there's the general civil. Thanks so much, Linda. Any discussion on this motion? Carolyn, your hand is up.
Yes, thank you. I guess I would like clarification on if it's combined to general civil, whether that's going to go into the same. So, oh, I'm sorry,
Please finish, Carolyn. We're running out of time.
No, I'm sorry. I didn't know if my
I know.
dog was
Just
barking.
talk louder.
Okay. What does that mean to combine it? Do you need to go back into general civil then?
I don't know if anyone has an answer to that question. Any further discussion?
Yes, I'd just like to say, I assume that means it's going to be further considered in the group that does general civil. That's what I understand the motion to mean, correct?
That's my understanding. Amos?
Thank you.
Yes.
As a member of general civil, I've got no problem adding the consumer debt issues, but if I understood Carolyn's question, I don't intend to reopen old categories of general civil. We're just going to consider these consumer debt issues.
Yeah, can I have one more comment, Your Honor? I know we're running over.
Just make the comment.
Yeah, I disagree that some of these categories need to be revisited again. They're litigation. Well, from what I understood in my participation in the general civil, which is brief, that all of these matters, again, auto litigation, that was all discussed by the committee, and anything that related to civil litigation in court was removed. So I don't see anything in these issues that's not the practice of law as it was discussed by the general civil, and I don't understand.
I don't think we removed anything. I thought that we had various different views, and we tabled whether we were going to say that people could or couldn't appear in court. So I think that the motion is clear that consumer debt's going to go into civil, and that group will do, look at this. That group may decide it wants to review things in greater detail. It may feel like it's already done the work and doesn't want to recreate the wheel, but we should leave it to that group and not decide right now what that group is going to specifically look at. Is there a further discussion? Okay, so can we please have a roll call vote?
Sure, thank you, Judge. Bashan,
Yes.
Bernelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
No.
Shining, Sarush,
Yes.
Spyro,
Yes.
and Judge Yu.
Yes.
Thank you, and the motion carries.
Thank you. So Leah, I'm just not really sure then, what do we need to do anything for health, housing, and collateral criminal at this point?
Well, I was gonna ask the group how you feel about that, but so I think that's one question. I know we have 11 minutes. The other is, for my understanding is we assigned employment to the income maintenance team plus anyone else that wants to join. So if we could identify who wants to join.
Yeah, we'll get there, but I need to know
So
about
health, housing, collateral criminal, the original and income maintenance, the original idea was no, you wouldn't need a team, but we could do the deep dive at a meeting. I think Ira raised a legitimate question, and the group may feel like that's not realistic.
I actually feel like it's not realistic, given what we need to do, and to not waste the experts' time, to have all of us and then the public asking questions. I just don't think it's a really good use of people's time. And so, I mean, I think that health, housing, collateral criminal could be even one person to do some investigation and come back to the group with recommendations. But that's just me. Does anyone feel differently? If so, could you please let us know?
Again, Your Honor, I'm not clear. Would all the people who are on health, housing, and collateral criminal then be combined and we'd have to do open meetings?
No, Carolyn, I'm sorry to be unclear. I apologize. And what we're saying is, Leah was she had so much faith in us, which I really respect, that she thought we could do the deep dive with health, housing, and collateral criminal, all 13 or 14 of us together with the public and the judge and the lawyers, and if you want the psychologist, all present with us, all firing questions to them with a list of tasks, and that we collectively as one group could decide which tasks should be done. But I'm thinking that it's too much for a larger group, and that a smaller group should be assigned to do that deep dive, come back with the recommendations, and then the larger group can ask questions. Does anyone disagree with that?
I guess, Your Honor, I just don't understand. I was on the health and I felt very passionate about that. So I don't understand who would be involved in a larger health, housing, collateral criminal group. Who would be?
It's not going to be a larger group. It's health will be separate, housing will be separate, collateral criminal will be separate.
Okay, thank you, Your Honor. I understand.
Okay, so I guess nobody is disagreeing. So can I have, I guess, I don't need a motion then probably. Okay, thank you, Leah. So now we should decide in the few minutes, 8 minutes we have left, what process we will use to have these groups populated. Steve Fleischman's motion included sort of the people already, so I don't think we need to address that for income maintenance and employment. With respect to, let's see, consumer debt and civil, do we want to talk about who wants to be on that?
Your Honor, I feel it's very important for me to be on
Right,
that. I was
Carolyn, Elizabeth rose her hand. You need to
Okay.
raise your hand. Go ahead, Elizabeth.
I'm just gonna say that I'd like to be part of that group for the civil.
Okay, thank you. Amos raised his hand.
I'm happy to join that group as well.
Thank you. Carolyn, you raised your hand.
Yeah, I was on that group before. I want to stay on it, Your Honor.
Okay, anybody else want to be on consumer debt civil?
I do. This is Julia Brynelson.
Thanks, Julia. Anybody else?
And you and Judge you and Steve, right? The original two.
I think that makes sense. Is that okay with you, Steve?
I'm happy to stay on.
All right. Is it okay to move then to the children custody, family, and the harassment issue? Who would like to be on that group?
Stephen Hamilton, I would, please.
Yes, thank you, Steve.
Elizabeth Olvera.
Thank you, Elizabeth.
Judge, this is Fariba.
Okay.
I'd like to be on that group.
Thank you. Sharon raised her hand.
I'd like to be on that group too.
Thank you, Sharon. And Dana raised her hand.
Same goes for me, Your Honor. Thank you.
Thanks so much, Dana. Anybody else want to be on that group? Okay. And so let's see. I think we've done everything except for health, housing, and collateral criminal. Who would like to do the deep dive on collateral criminal? I'm happy to do that and talk about tasks. Sharon, do you want to do that too?
Yes, I'd like to continue with that.
Yeah. Anybody else? Okay. Who wants to do housing?
I'm happy to be on housing.
Was that Steve Hamilton or was that Amos?
I'm sorry, I couldn't hear who the first person was on collateral criminal.
Sharon.
Sharon and Erica Yu. Sharon,
Oh, okay.
Yeah, thanks, Linda. I'm so sorry.
Okay.
What about on, I don't know, I think I heard someone say on housing. Who wants to do housing? Was that Amos?
Yes.
Thank you, Amos.
Yeah, I'll
Anybody
do,
else?
Ira, well,
Ira?
I think I'm on it already, but yes.
Okay, you guys will talk about the tasks and give us a recommendation on the tasks. And then what about health?
I think Jane, I would like to continue on with that, Your Honor.
Thank you, Carolyn. Anybody else?
I can work on that, Julie Felmuth.
Thank you, Julie. Okay, so I think we have at least 2 people per group. Now, I'm so sorry that I rushed this a little, so I want to make sure if anybody else wants to join this, any of these groups, can you please speak up right now?
Stephen Hamilton, I'd like to be added to civil too.
Okay, great, Steve, thanks. Anybody else?
Julie Felmuth, I'd like to be added to housing.
Okay, Julie, thank you. Anybody else?
Your Honor, I've raised my hand. I just wasn't sure you could see it.
Oh,
That's okay. So I'm already on family. That's okay. But I think I should also be on the housing because we do have a lot of self-help litigants who come in for that, and I would really like to be involved.
right, and then the elder abuse issues that were raised by Mina, so that would be good. Okay, anybody else want to join anything else? All right, let me just check with Linda and Leah to see if there's anything else that we would like to talk about today.
Yes, I think we want to talk about in 4 minutes, so maybe just we'll get to August. This question of for the August meeting, will we just get to the recommendations on children in custody, consumer debt, employment, and family, or will we have time to do that deep dive facilitated discussion, albeit informed by the work that's done in the interim with the team on health, housing, or collateral criminal?
What's the date of the meeting in August?
We haven't finalized a date yet.
Because August is in 2 weeks, and I hate to have those health, housing and collateral criminal. I mean, I think maybe Sharon and I could probably do collateral criminal by sometime in August, because it's, I think with respect to the record clearance and infractions, it's pretty contained. Sharon, what do you think?
I think so, with the caveat that I'm going to be on vacation from the 13th through the 20th
Of July?
of August.
Oh, okay. So why don't we say that we think we can give you a deep dive on collateral criminal? And then, is that enough, Leah?
Yeah, I think so. We just wanted one. So we'll get back the recommendations on all of these others in the middle bar here on your slide, and then do the deep dive in collateral criminal in August.
Okay. Anything else from staff?
No, thank you.
Yes, since all of these meetings, since all of these teams, for the most part, are more than 2 people, I'm going to send out doodle polls to try to schedule a series of meetings on those topics in that middle category.
Thanks, Linda. I do see Sharon and Fariba's hands up. I want to just make sure and see if they have anything they'd like to add. No. Fariba?
Sorry, I forgot to put my hand.
Me too.
Anybody else on the who is on the committee would like to say anything? Okay, so you guys are all bruised up now because I've been pushing us through, and I sincerely apologize. But look, it's 1:59 and we got a lot done. So thank you, everybody. I wish we were all in person because I usually bring chocolate to the meetings to say sorry, but I promise I owe you guys all chocolate when we can get together in person. Thank you all so much.
Judge, thank you so much for serving as chair for this meeting.
Sure.
Yes, thank you, Judge.
I'm very happy to give Chris back the baton next time, though. Take care, everybody. All the best.
Thank you.
Thank you.